assisted by our standing committee members, a team of stellar lawyers from across the country who are handpicked and whose practices are in the litigation arena and who are deeply committed to the work of a strong judiciary. As you know, David Brown joins us here today, and I can tell you that all of these people work diligently to do what we always aspire to do, and that is to provide a fair and independent rating within the time frame that's established by the Senate Judiciary Committee. To be a nominee to the Supreme Court, one must possess exceptional professional qualifications, and as such, our investigation of a nominee to the Supreme Court is much more extensive than that for other federal courts. In addition to the usual approach of having a lead evaluator conduct and report on the nominee, every member of the committee from his or her own circuit conducts a separate evaluation which is given to us. And second, while the committee members review the writings and opinions of the nominee, we engage academic reading groups. Here we had 2 academic reading groups, distinguished professors from the law schools of the University of Mississippi and Belmont University, and a 3rd professional reading group that included Supreme Court practitioners and former clerks, among others. There were 34 members of these reading groups. They read the opinions and the writings of the nominee, and they independently evaluated factors such as the judge's analytical abilities, clarity of writing, knowledge of the law, application of the law to the facts, harmonizing a body of law, reasoning, scholarship, and the ability to communicate effectively. And our committee also had the benefit of evaluating Judge Barrett in 2017, when then Professor Barrett was nominated to the 7th Circuit Court of Appeals, where she now serves as judge. And we interviewed Judge Barrett for over 3.5 hours, Ms. Roberts and I, and we received additional information from her in the interim. The Standing Committee concluded that Judge Barrett's integrity, judicial temperament, professional competence met the very high standards for appointment to our Supreme Court. Our rating of well-qualified reflects the consensus of her peers that know her best. Thank you, Chairman Graham and Ranking Member Feinstein, for your staff's accommodating us to be here today. They were professional and gracious at every turn. Thank you.
Well, thank you. Before we turn to Ms. Roberts, there's contention on our side about the ABA at times, but as chairman, I always have considered the input to be important, even when I disagree with it. And during my time, we've continued the practice of ABA input, and I hope those who follow me will do so. Ms. Roberts.
Thank you, Mr. Chairman, Ranking Member Feinstein, and members of the committee. As my colleague just introduced, I'm Pamela Roberts, and I'm the lead evaluator for the nomination of Judge Amy Coney Barrett to sit as a justice on the Supreme Court of the United States. It is my honor to be here today and to present the testimony on behalf of the committee's evaluation of Judge Barrett's professional qualifications. Let me first start with what the committee did not do. We did not base our rating on or seek to express any view regarding Judge Barrett's philosophy, political affiliation, or ideology. We also did not solicit information as to how Judge Barrett might vote on specific issues or cases that might come before the Supreme Court. Rather, the Standing Committee's evaluation of Judge Barrett is based solely on the comprehensive, nonpartisan, non-ideological peer review of the nominee's integrity, professional competence, and judicial temperament. In evaluating integrity, We consider the nominee's character and general reputation in the legal community, as well as the nominee's industry and diligence. Judge Barrett has earned and enjoys an excellent reputation for integrity and outstanding character. Judges and lawyers alike uniformly extolled the nominee's integrity. We can recount a few comments, such as, she's incredibly honest and forthright. She's exactly who you think she is. Nothing about her is fake. She is good, decent, selfless, and sincere. She is an exemplar of living an integrated life in which her intellect, integrity, and compassion weave the different threads of her life together seamlessly. On the basis of these and many, many other laudatory comments and analysis, we received through our comprehensive evaluation, the Standing Committee concluded that Judge Barrett possesses the integrity required of a well-qualified rating. Professional competence encompasses such qualities as intellectual capability, judgment, writing, and analytical abilities, knowledge of the law, and breadth of experience. A Supreme Court nominee must possess exceptional professional qualifications, including an especially high degree of legal scholarship, academic talent, analytical and writing abilities, and overall excellence. Judge Barrett's professional competence exceeds these criteria. In our evaluation of Judge Barrett's professional competence, the members of the Standing Committee not only evaluated the reports mentioned by my colleague, by the practitioners and the academic reading groups, but then went further to obtain the views of lawyers, academics, and Judge Barrett's judicial peers. Descriptions of her intellect are captured with comments such as these. She is whip smart. She's highly productive, punctual, and well-prepared. A brilliant writer and thinker. She's quite pragmatic. Judge Barrett is an intellectual giant with people skills and engaging warmth. An amazing student. This came from a professor, obviously, without question, the smartest student I have ever taught. But put it simply, one said, the myth is real. She is a staggering academic mind. Given the breadth, depth, and strength of the feedback we received, the Standing Committee concluded that Judge Barrett had demonstrated professional competence to exceptional and sufficiently outstanding to be rated well qualified. In evaluating her judicial temperament, the Standing Committee considers a nominee's compassion, decisiveness, open-mindedness, courtesy, patience, freedom from bias, and most of all, commitment to equal justice under the law. The following comments provide insight into her demeanor as a jurist. She's always willing to be helpful, engage with others on a topic, even when she has a different philosophy. When she writes a dissent, she is collegial. She's an efficient judge. She is always prepared. At oral argument, she asks insightful questions. There's never a hint of sarcasm in her questioning. She is also a good listener. She has a calm, scholarly temperament. Judge Barrett has demonstrated stellar judicial temperament in all settings and meets the standard of a well-qualified. In conclusion, Judge Barrett meets the highest standards of integrity, professional competence, and judicial temperament. It is the opinion of the ABA Standing Committee on the Federal Judiciary that Judge Barrett is well qualified to serve as an Associate Justice of the Supreme Court of the United States. Thank you so much.
Well, thank you, and to the extent that the American people could hear what you had to say, I think it would be reassuring in terms of the Bar Associations taking the time and effort to do something this important. We're all grateful. Were either one of you involved in the Justice Kagan Sotomayor confirmation process?
No, sir.
Okay. The reason I mentioned that, the same things that were said today about Judge Barrett were also said about Justice Sotomayor and Kagan, and quite frankly, every other nominee that I've had the pleasure to associate with on the Judiciary Committee. In terms of the three areas that you evaluate, how much time and attention went into this, Ms. Roberts?
On behalf of the entire committee,
Yes, I mean,
thousands of hours.
okay. Mr. Knoll, are you in agreement with the summary given by Ms. Roberts?
Yes, indeed. Yes. Yes.
In terms of, both of you are active in the practice of law?
Except for the last 2.5 weeks.
Yeah. Well, I can't show favoritism here, Ms. Roberts, but I know you, and it's good to have somebody without an accent come to the committee. Mr. Knoll, are you involved in the practice of law?
I'm a full-time practicing senior partner in my law firm, yes.
Okay, and you have people's personal interest and property rights in your hands as a lawyer, is that correct?
I do, yes.
Same for you, Ms. Roberts?
Yes.
You're very well known in our state, by the way. Simply put, would both of you feel comfortable going before Judge Barrett?
Absolutely.
Absolutely.
Think
yes,
you
sir.
folks would get a fair shake?
No doubt in my mind.
I would agree with that.
Thank you all. You've done the country an invaluable service. Thank you. Senator Feinstein.
Well, I'd like to say thank you, too. One of the things that I've observed over my tenure on the committee is really how extraordinarily valuable the ABA has been, and as a non-lawyer, particularly to me. So I just wanted to be able to say a word of thanks to you, and I hope you keep it coming. We very much welcome your advice, your counsel, and your legal professionalism. So thank you.
Thank you.
That's it. Thank you.
Thank you. I have a list of letters supporting the nomination of Judge Barrett I would introduce for the record in this folder. Without objection, Senator Cornett.
Mr. Chairman, I have a letter from the Independent Women's Voice in support of the nominee. I'd ask unanimous consent that it be made part of the record.
Without objection. On our side, would anybody like to say something? You don't have to. Anybody like to ask questions? Senator Kennedy?
I just wanted to thank you for all your hard work and the time you spent on this.
Thank you.
Senator Coons, anyone?
Yes, if I could. Just two questions for you. One on a broader issue of the ABA and its role in confirmation, and then another on diversity in the federal courts. President Trump's named 10 judicial nominees who were subsequently rated by the ABA as not qualified. And by comparison, not a single judicial nominee of the Obama administration was rated as not qualified. And these ratings have led the Assistant AG for the Office of Legal Policy to write in an editorial that the ABA evaluates nominees of Republican presidents more harshly than those of Democratic presidents. Does the ABA take political considerations such as this into account when it provides this committee with ratings?
Thank you, Senator Coons. Our evaluations are done in an apolitical, neutral, impartial way. We do not take into account political affiliation, religious preference, philosophy, or personal views. We focus solely on the professional qualifications to serve.
If I might add, Senator, that under the two administrations, was a different practice. Under the Obama administration, the ABA process actually goes forward before going to the Senate committee.
Correct.
And so you don't have, it addresses problematic nominees before they're formal nominees.
Correct. One of my repeatedly stated concerns has been racing forward with nominees before we get your input on qualification, which I tend to rely on. One other question, if I might. By nearly every metric, the Trump administration's judicial nominees have been among the least diverse of any president in generations. He's made 50 nominations to the circuit courts, not one of whom was black. In fact, over his 200 nominations, about 85% have been white and only 25% have been women. Yesterday, in response to a question from Senator Booker, Judge Barrett could not name a single book, study, or law review that in any way addressed racial discrimination and its legacy in American law. I'm not suggesting in any way that that's disqualifying. I'm simply saying that at a time when such books are bestsellers, at a time when this central challenging issue for the United States and for our legal system about how to address, recognize, combat the legacy of racial discrimination, I just wondered if you could briefly speak to the importance of diversity on the bench and in the legal community more broadly.
Senator, we're not here to speak for the American Bar Association. We are the independent body of the Standing Committee on the Federal Judiciary. But in terms of this evaluation and the work that we did, I can share with you that of the hundreds of people that we reached out to who confided in us and gave us their very candid views, we didn't hear a hint of any concern by anyone that this nominee suffers from some kind of malady in terms of
Let me be
discrimination.
specific and clear. I was not intending to imply that in any way. Her failure to respond to Senator Booker's question yesterday with a specific example, I did not mean to imply, suggested any bias. Just it led to me to question whether or not having broader diversity on our courts would bring into the decision-making role those who bring personal insight and experience, and whether or not all who serve on our bench and in Congress should be more aware of this challenge facing our nation.
If I may, Senator, I just would remind the committee that there are 2 questions in the Senate Judicial Questionnaire that the nominees complete that do address diversity. One goes to membership of any organization or club that might discriminate, and the other question goes to a view of diversity and is usually followed up in the face-to-face interview by the evaluator and the nominee. And so there is some intentional discussion about those important issues.
Mr. Chairman,
Thank you.
Mr. Chairman,
Yes, Senator Corning.
Mr. Chairman, it strikes me that the nominee understands diversity, appreciates diversity. She's got 2 children she adopted from Haiti. So I don't think she needs to have anybody preaching to her about the importance of diversity. Her own family is racially diverse, and I think it speaks volumes of about her character and her husband's character for what they have done in terms of adding to their already large family by adopting these 2 children from Haiti.
Okay, anybody else? Senator Cruz.
Mr. Chairman, I wanted to thank both of the witnesses for the hard work. I know you put a lot of time into these interviews, and thank you for the thoroughness with which you approached the job, and thank you for relaying to the committee what you found from those interviews. I also wanted to enter into the record a letter from First Liberty, which is a legal organization that defends religious liberty, in which they support the confirmation of Judge Barrett and say in particular that we're confident that Judge Barrett will protect the religious freedoms and constitutional rights of all Americans.
Without objection. Thank you both for the input to the committee, for all the time and effort. Yeah, I think it's invaluable to the committee and the country. And tell General Rives that I said hello. He was my boss when I was in the Air Force. Thank you very much. You're dismissed.
Thank you.
Thank you.
Our second panel, Take your time.
So, Lindsay, you'll recess for how long?
We'll,
Just so I want,
yes, for,
an hour?
yeah, 30 minutes probably. We'll try to get it done as soon as we can. Are we ready there? Okay, thank you. So, here's what I'll do. We have 8 witnesses, 6 are virtual, 2 are with us in person. 4 supporting the nomination, 4 opposed. And we will do it in the order that I call out, but just be patient with me. Dr. Bhatti, Carefree Medical, Lansing, Michigan, are you with us?
Yes, sir, I'm here.
How do you say your name, sir?
Bhatti is my last name.
Okay, thank you, Dr. Bhatti. The Honorable Thomas Griffin, retired judge, U.S. Court of Appeals for the District of Columbia, Washington, D.C. Judge, are you with us?
Yes, sir.
Thank you. Ms. Kristen Clark, President, Executive Director, Lawyers Committee for Civil Rights Under Law, Washington, D.C. Ms. Clark?
Yes, Chairman.
Thank you. Professor Prakash, Prakash, James Monroe, Distinguished Professor of Law, University of Virginia School of Law, Charlottesville. Professor, are you with us?
Here.
Oh, okay, I'm sorry. I apologize. Did I get your name right?
Very much so.
Oh, good. Thank you, sir. Ms. Crystal Good, Charleston, West Virginia. Ms. Good, are you with us?
Yes, Chairman, I'm here.
Okay. Miss Amanda Rauh-Bieri, Associate Miller, Canfield, Grand Rapids, Michigan.
Yes, Chairman, I'm here.
How do you say your name, ma'am?
It's Rao Beery.
Thank you. Miss Stacy Staggs, Little Lobbyist, Charlotte, North Carolina.
Yes, Chairman, I'm here.
Thank you. And last is Miss Laura Wolk. Is that right, ma'am?
Yes.
Thank you. From Washington, D.C. So, Dr. Bada, will you please lead us off? You each have 5 minutes, and they'll be subject to questioning by the committee. And thank you all for taking the time to attend and give us your input.
Well, thank you, Chairman Graham, and thank you to this committee for welcoming me here. My name is Dr. Farhan Bhatti. I'm a family physician practicing in Lansing, Michigan, and the CEO of a nonprofit, Carefree Medical, which provides medical, dental, and optometry care to low-income, underinsured, and uninsured individuals. I'm also a board member and Michigan State lead for the Committee to Protect Medicare, a national organization of physicians in more than 40 states who want to make sure our patients get the care they need, regardless of financial status. Most of my patients are Medicaid recipients, men and women who work 2, sometimes 3 jobs. Because Michigan expanded Medicaid in 2014 under the Affordable Care Act, more than 750,000 Michiganders can now get the treatment they need. There are countless stories from my daily work I could present, but I will share just 2. The first is a middle-aged male who had a long history of uncontrolled diabetes and who recently acquired Medicaid. Since he wasn't able to afford insulin before getting Medicaid insurance, we tested his blood in our office and found his hemoglobin A1C had risen to 17.5%, when normal is 5.6% or below. An A1C of 17.5 means his blood sugar was averaging 455 milligrams per deciliter. And as a physician, my goal is to have diabetic patients average 150 or less. Blood sugar as high as his, if left untreated, will almost certainly lead to death. Because of the ACA, I was able to start him on an intensive insulin regimen, and within 4 months, his blood sugar dropped more than 200 points. The blurred vision he was experiencing significantly improved. His kidney function improved, and he was able to find a job. The ACA literally saved this man's life. Another story I'd like to share involves a patient with bipolar disorder who was doing well and was stable and healthy until she lost her job and her health insurance due to COVID-19. I had been prescribing a medication that worked wonders to keep her mood stable, but without insurance, that medication costs more than $1,200 per month, which she simply couldn't afford. I tried prescribing older, inexpensive generic medications so she could pay cash for them, hoping we'd find an effective alternative. None of them worked. She developed a severe depressive episode. Her energy and motivation vanished. She gained significant weight because of the side effects of the older generic medications. She had uncontrollable crying spells, and she experienced suicidal ideation. Thanks to Michigan's expansion of Medicaid as allowed under the ACA, my patient's suffering ended because we eventually got her enrolled into Medicaid. We resumed the medication she desperately needed, regulated her dopamine, and stabilized her mood. She can once again contribute to the economy and support herself financially. These are just a fraction of the many positive outcomes of the ACA I have witnessed over the years. Simply put, as a frontline doctor, I witness every day how the ACA has improved, is improving, and will continue to improve the lives of ordinary, hardworking people. For those without health coverage, they live in fear that they are only one illness or one injury away from bankruptcy. Medical bankruptcy in this country is in the hundreds of millions of dollars. It breaks my heart. So during a pandemic that continues to kill 1,000 Americans each day, people need the ACA and the freedom it provides now more than ever. Without the ACA, insurance companies would be able to discriminate against a new generation of people with COVID-19 related pre-existing conditions, and anyone with a pre-existing condition, by refusing to cover them or by raising costs. As a family doctor who cares deeply about my patients, I'm grateful to be here today to advocate for them and for all patients in our great nation. And I'm here to urge against striking down this life-saving law, or confirming to the Supreme Court anyone who would seek to do so. As a doctor, I can't talk with expertise about concepts like originalism or textualism. As a doctor, however, I can talk about the real-world harm of ending the ACA to the real-life Americans who have to choose between going to a doctor or buying groceries. And as a physician who engages with other doctors across the nation, I share the concern that any judge who opposes the ACA endangers a lifeline that my patients count on to stay healthy, and in many cases, to stay alive. Thank you again for the opportunity to share my patients' stories with you.
Thank you, sir. Thank you very much. Judge Griffin.
Mr. Chairman, Ranking Member Feinstein, and members of the committee. From 2005 until last month, I was a judge on the U.S. Court of Appeals for the D.C. Circuit. But before that, I spent several years and many long hours in the hearing room where you are now as the nonpartisan Senate Legal Counsel. I'm appearing to you virtually, but it's good to be back in a room where I spent so much time working with such great senators. I'm honored by the invitation to speak in support of the confirmation of my friend, Judge Amy Coney Barrett, to the Supreme Court of the United States. As you and the nation has seen during these hearings, Judge Barrett is supremely well qualified to join the other esteemed members of the court. A recent survey found that over 2/3 of the American people believe that Supreme Court justices base their decisions primarily on the law and not on politics. In light of that, there's something deeply disturbing about much of the debate surrounding judicial nominations in our nation. Many political leaders and pundits assume that a judge will cast your vote based on partisan preference. Such explanations, typically made for short-term political gain, do much harm. They undermine public confidence in an independent judiciary, which is the cornerstone of the rule of law. The rule of law is a fragile possibility that should be more carefully safeguarded by our leaders. I agree with the Chief Justice. Quote, "We do not have Obama judges or Trump judges, Bush judges or Clinton judges," he said. "What we have is an extraordinary group of dedicated judges doing their level best to do equal right to those appearing before them." Having served 15 years on the DC Circuit alongside judicial appointees of every president, from Carter to Trump, I have seen firsthand that judges can and do put aside party and politics in a good faith effort to correctly interpret the law. Justice Kagan made the same point at her confirmation hearing. She flatly rejected the idea that difficult cases turn on, quote, "what's in a judge's heart," close quote. Instead, as she put it with her characteristic wit, it's law all the way down. That is precisely the type of jurist Judge Barrett has been. In Price versus City of Chicago, she ruled against pro-life litigants who challenged an ordinance that barred them from approaching women near abortion clinics for the purpose of leafleting, protesting, or counseling. Even though there were substantial arguments under the ordinance that the ordinance violated the First Amendment under an aggressive reading of recent Supreme Court precedent, Judge Barrett joined an opinion that followed binding precedent and upheld the ordinance. She displayed the same impartial approach in rulings that allowed the first federal executions in 17 years to proceed, regardless of her personal views on the death penalty. As constitutional scholar Jonathan Adler pointed out, quote, "These decisions certainly are not in line with church teaching and further suggest that Judge Barrett applies the law whether or not that coincides with her personal beliefs." Judge Barrett brings something else to her work as a judge that is especially vital to our nation at a time when many regard those with differing views as enemies, not friends. In the words of Judge Lawrence Silberman, my friend and distinguished former colleague on the DC Circuit for whom Judge Barrett clerked, quote, "Amy combined a powerful analytical ability with an innate kindness and sense of decency." The public record makes clear Judge Barrett's powerful analytical ability. I don't think we can overstate the importance of her kindness and decency. Judge Barrett's colleague at Notre Dame, O. Carter Sneed, says of her, "She genuinely seeks to understand others' arguments. Time and again, I have seen her gently reframe a colleague's arguments to make them stronger, even when she disagreed with them." Professor Lisa Gross-Sun of Brigham Young University observes, quote, "Amy always welcomes the opportunity to learn more from people whose perspectives differ from her own. She's always very generous to other people's arguments." Finally, while some of the discussion about Judge Barrett's faith has been tinged with bigotry, some of it comes from a sincere desire to know whether her faith will dictate her decisions as a justice. As a person of faith who served on the DC Circuit, let me assure you it will not. The oath that every federal judge must take is intended to transform the citizen into an impartial judge whose loyalty while performing her judicial role is to the Constitution and laws of the United States and not to any president, party, or religion. In taking the oath, the judge makes a solemn promise with God as witness that when acting as a judge, she will be a different person than when she is not acting as a judge. Robert Bolt's portrayal of Thomas More in A Man for All Seasons captures this point simply and powerfully. "What is an oath?" More asks, "but words we speak to God." In other words, for a person of faith, the judicial oath is a promise to the nation and to God that she will not do the one thing her secular critics most fear: reach for outcomes based on her religious worldview. When wearing the robe, there is no conflict between following God and Caesar. It's Caesar all the way down. I thank you for this opportunity and look forward to any questions that you might have.
Thank you, Judge, very much. Ms. Clark?
Chairman Graham, Ranking Member Feinstein, and members of the committee, thank you for the opportunity to testify in connection with the Supreme Court nomination of Judge Amy Coney Barrett. My name is Kristen Clark, President and Executive Director of the Lawyers Committee for Civil Rights Under Law, one of the nation's oldest civil rights organizations. Founded in 1963 at the request of President John F. Kennedy, we turn to the courts to protect the civil rights and voting rights of Black people and other communities of color across our nation. We've conducted an exhaustive review of Judge Barrett's writings, speeches, and decisions during her time on the court. Judge Barrett's views are far outside the mainstream, and for evidence of this, one need look no further than her own words before this committee this week. Judge Barrett would not say whether voter intimidation is illegal, though outlawed by Section 11B of the Voting Rights Act and federal criminal laws. Judge Barrett would not concede that voting discrimination still exists, saying she could not endorse that proposition and calling it a very charged issue when questioned about the court's Shelby County versus Holder decision. Even Chief Justice Roberts, the author of that devastating ruling, noted, quote, voting discrimination still exists. No one doubts that. Judge Barrett would not say whether absentee ballots are essential to voting in the pandemic, calling it a matter of policy on which she can't express a view. Judge Barrett has left open the possibility that she would participate in cases that may arise out of the election now underway. It's troubling that she would not recuse herself under these circumstances, and her stance sends a disconcerting message to the 17 million Americans who have voted to date, with millions more to come. These are voters who want their ballots and not an election season court pick to determine the election outcome. Her record reflects the same. In Cantor versus Barr, she suggested the right to vote deserves less protection than the right to own a gun. And that's a radical point of view, no matter what one's view of the Second Amendment. In her words, she described the right to serve on juries and to vote as belonging only to, quote, virtuous citizens. She's made clear that her judicial philosophy has been molded by the late Justice Scalia, who described the Voting Rights Act as, quote, a perpetuation of a racial entitlement. When asked if she agreed with this, she refused to answer. During these hearings, Judge Barrett has gone to great lengths to distance herself from the reality of voter suppression and voting discrimination that we face today. This should sound an alarm to anyone in our country who cares about protecting voting rights for all Americans. In this moment, we're in lower courts fighting efforts to purge voters from the rolls, efforts to shutter polling sites in communities of color, burdensome restrictions such as notary and witness requirements for those casting absentee ballots during the pandemic, and more. And this term, the court will decide a case arising out of Arizona, where the issue concerns racial discrimination in voting under both the Constitution and Section 2 of the Voting Rights Act. Given Judge Barrett's unwillingness to recognize the threats that Black people and communities of color face in voting, I'm deeply concerned about how she would handle this case and many other such cases that will come before the court. A brief word on employment discrimination. Judge Barrett revealed alarming insensitivity to racial harassment in the workplace in Smith versus Illinois Department of Transportation. There she held that a Black traffic patrol driver was not subject to a hostile work environment, even though coworkers frequently subjected him to use of the N-word. Judge Barrett concluded that this was an egregious racial epithet, but concluded that this sort of racial hostility was not enough to prove discrimination. This stance is simply incomprehensible. The nomination of Justice Barrett arises at one of the most tumultuous times in our nation's history. We're wrestling with a pandemic, protests about unconstitutional policing practices, racial injustice, and more. Our nation deserves a justice who is committed to protecting the hard-earned rights of all Americans, particularly our nation's most vulnerable. For these reasons, the Lawyers Committee for Civil Rights under Law opposes Judge Barrett's nomination. Thank you.
Thank you, Ms. Clark. Professor Prakash?
It's a pleasure and an honor to be with you here today to discuss Judge Barrett. Thank you, Chairman Graham. Thank you, Ranking Member Feinstein and members of the committee. I had the pleasure of working for the great Senator Alan Simpson over the summer, and so I fondly remember this building. We heard the ABA rate the judge as well qualified. I think the only reason why she wasn't rated higher is that there is no higher rating by the ABA. I think she's uber qualified. I think, to use a sports metaphor, she's a five-tool athlete. She is brilliant. She's a tremendous educator. She's an institutionalist. She's a role model, and I'll say finally, she's an originalist, and I think that's a good thing. So I'll briefly go over some of these points, and I certainly welcome your questions. With respect to her brilliance, I think her articles reflect a deep appreciation of complex issues and ability to break down those complex issues in a manner that people can understand. I would point you to her article entitled "The Supervisory Power over the Supreme Court," where she discusses the Supreme Court's assumption of power to prescribe procedural and evidentiary rules in the 1950s over the inferior courts, and how that is problematic given that Congress has occasionally granted the Supreme Court authority to impose rules on the lower courts. And so it's an interesting time where she's basically a nominee to the Supreme Court and criticizing the Supreme Court's conclusions in this regard. I think her discussion of precedent is very nuanced, and I think it reflects a willingness to not overturn the entire constitutional order in order to get things right. She properly notes that judges do not need to reconsider precedent in every case, and I think that is utterly and totally appropriate. But don't just take my word or the word of the ABA. Harvard Law professor Noah Feldman has said she's brilliant, and he also said she's conscientious. I agree with both of those adjectives. As an educator, you know that she's won the Teacher of the Year award 3 separate times, the Distinguished Professor of the Year award, and I think this reflects her attention to students, her care, her evident care for them. But we must never forget that justices and, of course, senators are educating the nation about our nations and laws, and I think that she will carry that task off with ease. As you saw during your testimony here, she's very good at breaking down complex concepts. I think she's an institutionalist, and I think that's reflected in her writing. She cares deeply about America. She does not want to burn the whole place down. And I don't think she'll do anything that brings the Supreme Court into disrepute. And I think she has good company because I think all the justices try their level best, even as they disagree with each other, to understand that each of the justices comes from the right place. As senators today discussed, they have the right values and they have the right instincts. She's a role model. I think Senator Graham has spoken to that at great length, and I won't go into it further. Finally, she's an originalist. Originalists basically believe that the meaning of the law that matters is the meaning at enactment, not what a judge or an executive branch would make with the law later on. And I'm reminded of the Biden condition, named after Senator Joseph Biden. You probably have heard of him. Senator Biden was disturbed by the Reagan administration's reinterpretation of the ABM Treaty, and he got this august body to add a condition to the INF Treaty, which said the interpretation of the treaty that matters is the interpretation that we jointly had when we consented to your ratification of the treaty. You cannot reinterpret treaties decades later. That is an originalist argument, and I would argue that's what every lawmaker wants, right? Lawmakers craft text. They get it marked up in committee. They take it to the floor. There might be amendments there. They then take it to the conference committee. There might be amendments there. They bring it back. They spend a lot of time thinking about that language, thinking about the context. And then what they don't want is some judge or some executive later on twisting that statute, twisting that enactment to suit some other purposes. And I think the alternative is, of course, the living constitution approach or the living statutory approach. But I don't think that honors you as lawmakers. It really leaves the lawmaking power with the judge or the executive officer. And if you look at our recent history, the living constitution has brought us things like the living presidency, a presidency, I think, that across all parties has acquired powers not granted to it by the Constitution. Think of the war power. Go back and read what Washington and others have said about it. It would shock you. Think about your role in treaties. It's greatly diminished. So I'll end with caution and hope. Originalists and conservatives will be disappointed with Judge Barrett because she will render results that they disagree with politically. That is entirely appropriate. And I'll end with a note of hope. Progressives should be happy because she will give the meaning to the laws that is appropriate at the time that you passed it. And I don't think that she's going to use her position to advance her personal or religious agenda. Thank you so much.
Thank you, Professor. Ms. Good.
Chairman Graham, Ranking Member Feinstein, members of the committee, thank you for having me. My name is Crystal Good, and I'm a sixth-generation West Virginian, a writer-poet, a small business owner, graduate student at West Virginia University, and an advocate for survivors of sexual abuse. I'm the daughter of a white mother and a black father, and I'm the proud mother of 3 brilliant children. These identities are all parts of me, but not all of me. Who I am today is only possible because at 16 years old, I had access to an abortion. As a minor in a state with a parental consent requirement, that access was dependent on a judge, because without a shadow of a doubt, I could not trust the adults closest to me. From the ages of 5 until I was 15, I was sexually abused by my white stepfather. He wasn't convicted until 2012, more than 30 years after the abuse began. When I told the grown folks in my life, they didn't believe me at first, and then refused to hold my abuse accountable once the truth was out. Later at 16, while in a relationship that brought me joy and made me feel safe, I, like 2.7 million Americans a year, had an unintended pregnancy. Immediately, I knew I wanted an abortion, a very safe medical procedure that 1 in 4 U.S. women will have in their lifetimes. For many reasons, including the decade of abuse she did not protect me from, I couldn't tell my mother. Instead, I sought a judicial bypass. I had to navigate not only how to get to the judge, but how to do so on a school day. I had no idea what I should wear or what information he would want. I thought I was going to court like on TV, but instead I was ushered into his chambers. It felt very intimidating. I told him I was a good student. I was a leader in my school. I had opportunities that many young women from West Virginia didn't. I wanted to go to college, to be a writer. I said, "Your Honor, I have a future. I choose an abortion." It felt like a miracle. An adult believed me. An authority figure deemed me to be in charge of my own body and my own future. I still think what might have happened if I didn't have a list of accomplishments, or if the judge didn't think I was competent enough to decide when to start my family, or if he believed the harmful stereotype I was raised to believe that Black girls were fast and promiscuous. Access to an abortion should not depend on our GPA, the color of our skin, where we live, or the luck of the draw. It should not depend in any shape, form, or fashion who your governor is or who is sitting on the Supreme Court. My entire childhood, every adult in my life had failed me. None of them deserved to make a decision about my body. I needed compassion and trust from my government. All I got was another barrier. There are thousands like me who are sexually abused by parents, guardians, and grown-ups who are supposed to support them. Today, 37 states require parental consent or notification for a minor to access abortion. Most young people do involve their parents in their decision. But for those like me who cannot, these kinds of restrictions make abortion hard to get because we have to travel, miss work or school, save up for weeks, and pay out of pocket. The average per capita income in West Virginia is $25,479. That's 1/7 of your Senate salaries. In Central Appalachia, Black and low-income white people struggle to access health care, including abortion, and to have our decisions respected. The Supreme Court has made historic decisions that uphold our rights and freedoms. My right to an abortion, the integration of my public schools, the Affordable Health Care Act that ensures that I have health insurance, and workplace protections for my transgender daughter. I have put my faith in the Supreme Court, and with this nomination, I am losing faith. Although the way I have chosen to create my family is demonized by some politicians, the reality is that we're like most families across the nation. I had an abortion. I have 2 sons and a daughter who is trans. I love my children. We are a proud Afro-Latin family. That's African American Appalachian. My story is my own, but represents so many people left out from the Supreme Court nominee hearings. An entire cast of people. That's CASTE, cast. President Trump has been clear that he would only appoint justices who would overturn Roe v. Wade. Unfortunately, through learning about Judge Barrett's record, I understand why the president believes she passes the test. Please listen to people who have had abortions. Hear us when we ask you, do not confirm this nominee. Our futures, our families, our lives depend on it. We too are America. Thank you.
Thank you, ma'am, very much. Ms. Staggs?
Good morning, good afternoon, and thank you for the opportunity to come and speak with you all today. I'm here to raise my voice against the nomination of Amy Coney Barrett and in support of the Affordable Care Act, as well as to share my family's story. While I appear in this room alone, I bring with me millions of families, including 130 million Americans who live with pre-existing conditions, and millions of Americans who dissent from this hearing and any confirmation to the Supreme Court before Inauguration Day. My name is Stacey Staggs, though I'm more frequently addressed as Mommy. I live in North Carolina with my husband and twin girls who have complex medical needs and disabilities. I advocate for their health care, education, and community inclusion with Little Lobbyists, a family-led organization advocating for children like my own. I share Judge Barrett's disdain for hypotheticals. As a behavioral interviewer, I know that past conduct is an indicator of future decision-making. And I am here today because Judge Barrett has repeatedly made statements that are hostile to the Affordable Care Act. A vote for Judge Barrett is a vote to take away health care. And a vote for Judge Barrett is a vote to strike down the law that saved the lives of my daughters. And my family is but one of many. Studies confirm the ACA has saved thousands of lives, especially in states that have accepted Medicaid expansion. And my family is a real-life example of the ACA's success. My twin daughters, Emma and Sarah, are adorable and active 7-year-olds. They're the lights of my life. And we balance a busy schedule of therapies and distance learning. Sarah Bean is my nature lover. She's happiest when she's splashing in the water or digging in the dirt. And Emma has a smile that lights up her entire face. Her favorite day is Tuesday, when we go to the farm for therapeutic horseback riding. I love them with the same joy and amazement I'm sure you feel for your own children. But 7 years ago, their recent birthday would have been too much to hope for. My husband and I were excited to learn we were expecting. We were surprised to learn we were having twins. I had excellent prenatal care, which is one of the essential benefits under the Affordable Care Act, and my pregnancy was going great until one day it wasn't. I was experiencing pain, so my doctor suggested I come down to the hospital for monitoring. And within hours, as my vital signs faded, I was rushed to the operating room where our small wonders were born via emergency C-section at 28 weeks. They were rushed to the neonatal intensive care unit where their survival was far from assured. We sat in vigil for weeks, learning an entirely new language of medical terms and holding our breath in between heartbeats on their monitors. I wasn't able to hold either girl for several weeks, but they were about the size of my hand. They had IVs in every extremity and skin so fragile you could see through it. Emma's birth weight was 1 pound, 9 ounces. She has never taken an unassisted breath or made a sound due to vocal cord paralysis. She has an artificial airway through a breathing tube, and she eats through a feeding tube that was surgically placed when she was 3 months old. Her twin sister, Sarah, was the bigger of the newborns at 2 pounds, and she needed heart surgery at 2 weeks old. That was the day percentages took on a new meaning for me. The surgeon told us his success rate for Sarah's procedure was 98%. Then he leaned in and said, but that doesn't mean much to the parents of the 2%. To this day, when I hear data points and discussion about recovery from COVID-19, for example, I'm immediately transported back to the surgical waiting room. When I was finally able to bring my babies home from the hospital for the first time after 110 days, we received an explanation of benefits with total claims nearing $1 million for their care. And in the first 7 years, our combined claims have surpassed 4 million. Without the protections of the Affordable Care Act, my daughters would have already hit their lifetime caps and now be rendered uninsurable. And we have primary insurance through my husband's employer. Medicaid support has been a lifeline for Emma because she needs 24-hour eyes-on care. Medicaid provides Emma with home and community-based services, including nursing, that allow her to stay home with us, where she belongs, instead of living in a hospital or other medical facility. Our country's in a public health crisis right now, one that's getting worse by the day. In this moment, we need our legislators to protect our families, to provide relief and support, to do the job we've elected them to do. We do not need to rush through the nomination of a Supreme Court justice who is on the record as hostile to the law that provides our healthcare protections. Shifting focus away from a relief package for families during a pandemic tells me the committee's priorities are not aligned with those of the American people. I urge you to listen to us and address the immediate need of COVID relief. Last, I'd like to thank you for the opportunity to give my testimony, to say healthcare is a human right and decency matters, and to remind you that as your constituents, my children and all children like ours are your children too. I hope you'll remember your duty to all of our children as you cast your vote to protect or to take away the healthcare their lives depend on to survive and thrive. Lastly, let me share that today is the first day of early voting in North Carolina. It's a big day for me here too. My next task is to cast my ballot accordingly. Thank you.
Thank you very much. I'm sorry I jumped out of order there. We got Ms. Amanda Roberi, then we'll get to Ms. Walk.
Mr. Chairman, Ranking Member Feinstein, and other members of the committee, I am deeply honored to speak to you about somebody who has had an outsized effect on my life as a former boss and a cherished mentor, Judge Amy Coney Barrett. I know Judge Barrett to be a person of the highest character, and I sincerely and enthusiastically support her nomination to be an Associate Justice of the United States Supreme Court. I had the privilege to serve as a law clerk during Judge Barrett's first term on the bench, joining her chambers shortly after her confirmation to the Seventh Circuit in 2017. From the very beginning, I saw Judge Barrett exhibit the rare and unique set of qualities that make her an exemplary judge. She is a brilliant thinker. She analyzes and writes about legal issues with striking clarity and precision. She is patient, thoughtful, and compassionate. She brings each of these qualities to bear on every case she decides. Judge Barrett is dedicated and disciplined, and as a judge, she is committed above all else to the rule of law. As she has said, and as I have seen, Judge Barrett understands that policy decisions must be left to the political branches. The role of a judge is to enforce the law as written. I have seen Judge Barrett put that unwavering commitment to the law into action in every case before her. She approaches each case with an open mind. She commits to the idea that either side might, in the end, have the better legal argument. Judge Barrett's open-mindedness is grounded in her compassion. She has spoken about viewing each decision from the perspective of the losing party. I saw her put that ethic into practice. It would be easier in many ways not to take this more demanding approach. But I learned from Judge Barrett that the law is about fairness over efficiency, and that every member of society and every party that comes before the court is entitled to equal justice. Judge Barrett is a judge who applies the law fairly and reaches the result that is required. And she writes with empathy and appreciates the real-life impact of her decisions. Alongside Judge Barrett's powerful intellect and enduring commitment to the law is her determination and discipline. In deciding cases, Judge Barrett has never relied simply on her extraordinarily sharp legal mind. She pairs that gift with a dedication to the full process in each case. She never takes a shortcut. She thoroughly examines the facts and the applicable law in each case. She's an intensely hard worker. Even the early rising clerks often arrived at her chambers to find the light already on underneath her office door. Even with her towering intellect and unfailing work ethic, Judge Barrett always took seriously the views of her law clerks. She would often pop over to our offices, ready to hear our perspective on a case or discuss a particular legal question. It's a testament to her respect and charity that she often walked the path from her office to mine, eager to hear my thoughts on the legal questions or to engage me in discussion over the thornier issues. It was in those conversations that Judge Barrett created a culture that encouraged us to voice our differing opinions, even if we thought she would ultimately disagree. She sees the value in discourse, and she fosters that value in her clerks, teaching us to be open and curious and humble about the law and life. And from what I saw as a law clerk, Judge Barrett approached her colleagues on the bench with the same gracious humility and openness that I experienced from her. Judge Barrett's impact on my life runs far deeper than legal training. As I said, I was in Judge Barrett's first class of clerks, and I joined her chambers in January of 2018, 2 weeks after my graduation from law school. I loved my time in law school, but I also spent much of it unsure of myself. I often tried to downplay my presence, afraid that I was wrong or inadequate. I wasn't certain I had what it took to succeed. Judge Barrett changed that for me. Her example and mentorship inspired in me confidence I didn't know I had. I can't point to a single event or a point in time when that change occurred. Change like that, formative change, happens gradually across hundreds of conversations and hours shared. Judge Barrett leads in law and in life with conviction, generosity, and courage. She inspires me to do the same. For example, I can tell you with certainty that I would not have the confidence to be here speaking to this committee without Judge Barrett's influence in my life. Judge Barrett has the rare gift of lifting everyone around her. She knows how to bring out the best in her clerks, spurring each of us to excellence. Judge Barrett has her own large family, but that didn't stop her from treating her clerks like family too.
Shortly after I arrived in chambers, my 3 co-clerks and I piled into the back of Judge Barrett's minivan, and she drove us from South Bend to Chicago for her first set of oral arguments. She cared deeply about each of us, investing time and encouraging us to cultivate rich, fulfilling, and well-rounded lives, both in and beyond the law. Clerking for Judge Barrett and being mentored by her is an honor. Judge Barrett has elevated my thinking, writing, and character, not by prescription, but simply by being herself. As a Supreme Court Justice, she would be a role model for generations to come, as she is for me. I am proud and honored to support Judge Amy Coney Barrett's nomination to serve as an Associate Justice of the United States Supreme Court. Thank you.
Thank you very much. Our last witness is Ms. Wolk. Did I get that right, Ms. Wolk?
You did.
Thank you.
Mr. Chairman, Ranking Member Feinstein, and members of the committee. My name is Laura Wolk, and I am a former student and mentee of Judge Amy Coney Barrett. In part because of her unwavering support, I am the first blind woman to serve as a law clerk on the Supreme Court of the United States. It is now my immense privilege to appear before you in support of Judge Barrett's nomination to that same great institution. You have heard over the past few days about Judge Barrett's judicial qualities, which are beyond reproach. But should you confirm Amy Barrett, the country will receive something far greater than simply an unparalleled legal mind. It will gain the service of one of the kindest individuals I have ever known. Her brilliance is matched only by her compassion, and her integrity is unassailable. I am not speaking in mere abstractions here. Rather, I have experienced these characteristics firsthand with life-changing results. Because I am completely blind, I rely heavily on assistive technology to compete on a level playing field with my sighted peers. Before arriving at Notre Dame Law School in 2013, I worked hard to ensure that the university would purchase backup copies of the technology I use. But upon arrival, I discovered that bureaucratic glitches left me without access to that technology. And on cue, my personal laptop immediately began to fail. Overnight, I found myself struggling to keep up in class, falling increasingly behind with each passing hour. I needed help, and I needed it fast. I'd been Judge Barrett's student only for a few weeks, but her graciousness and warmth gave me hope that she could provide me with that assistance. Even so, I maintained relatively low expectations. Based on my past experience, I assumed that Judge Barrett would simply direct me to the proper bureaucratic channels, which could still take weeks, if not longer, to navigate. But Judge Barrett did something altogether different. She silently listened with deep attention as I explained my situation, giving me the freedom to let down my guard and come apart. As a disabled person, I am accustomed to acting as if I have everything under control, when in reality, the world feels like it is spinning out from under me. But in front of Judge Barrett, I was able to let the mask slip and indeed to disappear completely. I poured out all my concerns, not just about technology and my worries about failing classes, but all the burdens I currently carried as a disabled woman navigating a brand new environment. When I finished, Judge Barrett leaned forward and looked at me intently. "Laura," she said, with the same measured conviction that we have seen displayed throughout her entire nomination process, "This is no longer your problem, it's my problem." I can't capture adequately the relief that washed over me at her words. Her offer was rare enough in its own right, but even when such offers are extended, many unfortunately do not follow through. It's hard to trust an offer of assistance, no matter how desperately it is needed or earnestly it is given. Not so with Judge Barrett. Anyone who has interacted with her knows that she is a woman of her word. She means what she says, and she says what she means. When she promised to advocate for me, she commanded my trust. To this day, I do not know what Judge Barrett did to solve my problem, itself a testament to her humility. All I know is that the technology arrived promptly, which in turn allowed me to excel and to place me in a position that would eventually allow me to apply for a clerkship on the Supreme Court. This encounter was the first in which Judge Barrett demonstrated the depth of her generous spirit, but it was far from the last. She has remained a constant source of strength, encouragement, and solace as I have pursued professional and personal opportunities with no roadmap to guide me. Through her mentorship, she has given me a gift of immeasurable value, the ability to live an abundant life with the potential to break down barriers so that I can leave this world a better place than I found it. Though I am here today to share with you my story, the very best aspect of that story is that it is hardly unique. Those who have had the benefit of knowing Amy Coney Barrett understand that she possesses a boundless font of energy and a radical sense of love that she is ever ready to pour out upon those lucky enough to call her teacher, boss, family, and friend. Judge Barrett will serve this country with distinction, not only because of her intellectual prowess, but also because of her ability to treat everyone as an equal, deserving of complete respect. As a beneficiary of both of these qualities, I urge you to confirm Judge Amy Coney Barrett to the Supreme Court of the United States. Thank you.
Thank you. Thank you all. I mean, your testimony in their own way was incredibly compelling in your life circumstances. We appreciate you sharing with the committee, whether you were in support or opposition to Judge Barrett. I really don't have any questions. I'm going to turn it over to Senator Feinstein. For the committee, if you want to grab a bite, we'll press on, but I just want to keep going. And we'll make sure everybody can ask questions that would like. Just one editorial comment. Ms. Walk, I'm very impressed with what you had to say. My sister is the executive director for the Commission of the Blind in South Carolina, and she's trying to bring about better outcomes, and I've just have some understanding of the world that you just spoke of, and maybe all of us can work together to provide some upper game here when it comes to services. Senator Feinstein.
Me? I would like to ask this question, if I may, of Crystal Good. I want to thank you for being here and sharing your very remarkable story with the committee. You've testified about a very personal decision that you made as a teenager to have an abortion. I'd like to just talk to you a little bit more about it because, as you and I both know, this is very hard for a girl or for a woman, and the personal circumstances are often not known. And so I was wondering if you would discuss with us what it has meant for you to have that right constitutionally to reproductive care.
Thank you, Senator Feinstein. I just want to say that, you know, I'm here today with the support and prayers of my pastor, of my friends and folks from Hills and Hollers, and my family, including my mom. And my mom and I have come a really long way. We've been on a very long healing journey to build a strong relationship. You know, her actions then were not excusable, but today I really understand how women like my mom, and men too, can fall prey to a culture of silence in churches and systems that knew what my stepfather was doing. And they protected him and not me. And so, you know, my right to access health care is why I am here today. And I am speaking from not a place of bitterness, but to give caution and concern in this nomination that the government cannot and should not create barriers to health care. Thank you.
Thank you very much. And it's very clear that you're a very strong person. I think we all wish you well. I would like to ask Dr. Bhatti, doctor, can I ask that question? Yes, okay. What would you say to people who have excellent health care coverage, as is true here for us in the Senate, to help us understand how important the ACA is for your patients?
Well, what I would say to folks with good insurance is that we're blessed. I have good health insurance too. We are blessed to be in a position. As a society, we sometimes punish people when the only mistake that they might have made is not choosing their parents wisely. And a lot of my patients fall into that category where, they are hardworking people. They go to work every day. They try to do their part to contribute to society. But their stories don't often get told. And that's why I'm here today, is to tell their stories and to let folks know that, the committee that I'm here representing and I as an individual value healthcare for all Americans. That's what this is all about, is making sure that every American has access.
Could I stop you for a minute?
Yes.
Because what's really important to me is, what do you think of the long-term consequences that the pandemic will have on this nation's health?
I'm very worried about the pandemic. We already have had, many 217,000 deaths. 8 million Americans have contracted COVID. 14 million Americans have lost their employer-based health care because they've lost their jobs since the beginning of the pandemic. And so we need to take bold action to get the pandemic under control in order to save as many lives as possible. I'm very concerned about our health response at every level of government.
Well, one other last question. What do you believe the most critical health response is to be beneficial? If you could speak a little bit about that and the numbers of people and your advice to us.
We need to do a better job at the highest level of government, starting with the federal government on down, with testing and contact tracing, and providing the resources to all the states that they need to do that. Because the numbers, as striking as they are a sharp underestimation of what the reality actually is, because we do not have the capacity at the ground level to perform as many tests as we need to know just how many Americans actually have COVID and just how many people have become sick and have died from COVID. So the numbers are a sharp underestimation. So anything that the federal government can do to empower each and every state to get more accurate counts, and then also to lead by example, where we need, masks should not be a partisan issue. Washing hands should not be a partisan issue. Social distancing should not be a partisan issue. And we need every elected member of Congress to lead by example by engaging in acts of public health that we need every American to engage in order to prevent the spread of.
Such as what kind of acts of public health?
I mean, basic things like having every member of Congress commit to wearing a mask, every member of Congress commit to social distancing, commit to not going into indoor places with more than 10 people, not holding large rallies where people aren't wearing masks, standing right side by side next to each other. Every member of Congress I believe, as a physician, has an obligation to lead by example. And that's what's going to help my patients the most is when they see elected officials that they trust leading by example and in participating in or taking part in simple public health measures to keep everybody safe.
Thank you very much, Doctor.
Dr. Rob Bowery, I'll turn it over to Senator Katie. Does that include protest?
I beg your pardon, Senator?
Would that include mass protest?
Any large gathering of people.
Yeah. Would that include rioting?
No, well, sir, I don't support rioting if that's what you're asking me. But
Well, I just want to make sure. Thank you. Senator Kennedy.
Thank you, Mr. Chairman. I just wanted to thank all of our witnesses for taking the time to come by. I particularly want to thank Professor Prakash. Am I saying that right?
Great.
Thank you, Professor. You did me a favor. You may not remember it, but one of my colleagues in my office is sitting behind me, Hannah Freyer. And you recommended Hannah to me. And I wanted to thank you for that. She's made you taught her well. She's made a substantial contribution to my office. Also, two of your colleagues, Paul Stephen and Dan Ortiz, are friends of mine. We went to school together, though at different schools. Paul and I were together at one school, and Dan and I were together at another, and please remember them to me. They are, in a word, brilliant, and they're good mates. So tell them I said hi. Certainly. And thanks again to everyone.
Here's one. Thanks, Senator Feinstein. I want to show you a photo of Nate Lau. I've produced a photo of an Illinoisan every day. And this one, Nate, photo is 8 years old, good-looking young man. It's the 8th anniversary of a surgery that saved his life, diagnosed with biliary atresia. He ended up needing liver transplant. Thank you, Lurie Children's, a wonderful hospital. Medical care cost more than $1 million in the first year of his life. And of course, it continues. He's in the 3rd grade. He plays soccer, video games, and playing with his younger sister. He, of course, now has a pre-existing condition for the rest of his life. And his parents tell me that lifetime limits might have cost him his life, period. So when we talk about the future of the Affordable Care Act, and Doctor, thank you for reminding us, remember this little fellow. What a good-looking young man he is. So I'm going to make a confession here that may not sit well with some of my colleagues. But when someone tells me, check the box, I'm an originalist, it isn't enough for me. It doesn't tell the whole story. In fact, it doesn't tell me much. Let me read to you what the mayor of Chicago, Lori Lightfoot, who's a friend, said a couple days ago in a news conference. I asked her if she was an originalist. Here's what she said. You ask a gay black woman if she's an originalist? No, ma'am, I'm not. That Constitution didn't consider me a person in any way, shape, or form because I'm a woman, because I'm black, and because I'm gay. I'm not an originalist. I believe in the Constitution. I believe it's a document the founders intended to evolve. What they did was set the framework for how our country was going to be different from any other. But originalists say that let's go back to 1776. Whatever was there in the original language, that's it. That language excluded over 50% of the people living in America today. So no, I'm not an originalist. So I don't take any comfort when people proclaim I'm an originalist. Trust me, I'm going to look at this Constitution, and having taken a good hard look at it, don't worry, we'll find the wisdom in these words. And we had a case here, which was very important. We talked about it over and over each day. And that was the Cantor versus Barr case, because Judge Barrett took the time to write a lengthy dissent. And she, being an originalist, took this adventure in history. She went back 400 years. Senator Kennedy, 400 years, there wasn't even a Louisiana maybe at that point. 400 years to find some guidance. What she missed in her conclusion is what's happening 400 yards from where she lives, where crime guns are coming across the border from state of Indiana into the city of Chicago and killing innocent people. The notion that we would somehow drop our guard and make it easier for people who are convicted felons to own firearms just doesn't make sense from where I'm standing. And I don't know if going back to the time of the British decisions on what to do with flintlocks is really much guidance when it comes to the reality today. Ms. Clark, if you're still on board, would you comment on Mayor Lightfoot's version of originalism and her take on it?
I have grave concerns about Judge Barrett's commitment to originalism and textualism as a theory of constitutional interpretation. It purports to rely on the understanding of our constitutional text at the time when the language was adopted, which is not practical in the 21st century. And it can lead to a high degree of speculation about the framer's subjective understanding. But I'd like, if I could, Senator, to read a quote from Justice Kennedy. The nature of injustice is that we may not always see it in our own times. The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all of its dimensions, and so they entrusted to future generations a charter protecting the rights of all persons to enjoy liberty as we learn its meaning. I think that Judge Barrett's strict adherence to originalism and textualism stands to turn our country back decades and runs the risk that we will exclude from the Constitution promise African Americans, women's rights, LGBTQ rights, and more.
Isn't it interesting, Ms. Clark, that many of the questions and issues before us still relate to the evolution of thinking beyond the original Constitution as it related to African Americans, for example, and particularly as it relates to women today? We are going through this. We're in the middle of this. And the folks in that Constitution, which I swore to support and defend, didn't get those two aspects right. Women didn't have a right to vote, and African Americans weren't even counted as full citizens, let alone having the right to vote. We are still debating that many hundred years later. Thank you, Mr. Chairman.
You, Senator Durbin, anyone on our side? Senator Lee.
Thank you, Mr. Chairman. Judge Griffith, I'd like to start with you if I could. In addition to being a judge on the U.S. Court of Appeals for the D.C. Circuit, you've also been a professor, and you've taught a course for a number of years at Stanford Law School regarding the unique, distinct role of the Article III judge. If I understand correctly, you've also started for the last few years teaching that same course at Harvard.
I'm with you.
And you'll be teaching that at Harvard and the University of Virginia this year.
Okay.
What do you tell your students are some of the most important lessons that you've learned as an Article III judge?
Yeah, thank you very much. Now, the danger is if I give you the full answer and the students are out there, they'll do better on the exams by hearing what I think. I'm just kidding. No, I came upon this course because I wanted to have a better understanding of what my role was as a judge. What am I supposed to do under the Constitution? What role am I supposed to play? And if I could just tell a quick story that I think captures what I've learned, both from being a judge and then from the courses and hearing interaction with the students. Tell the story. It happened the day after I was confirmed by the Senate for my seat on the D.C. Circuit. It was a happy day for me. I was in my office. I was the general counsel of Brigham Young University at the time, and I was the recipient of many congratulatory phone calls from people from around the country who I had known and worked with before. One was from a fellow he and I had been at the same law firm in Washington, D.C., and he had clerked for a distinguished member of the D.C. Circuit who's long since passed away, and then went on to clerk on the Supreme Court. And so he wanted to give me some advice about being a judge. He said, "Are you open for advice?" And I said, boy am I. I'm teachable. And he said, "I'll tell you what I was told the first day in my judge's chambers in the D.C. Circuit." He sat me down and he said, "Here's how we go about our job. The first thing that we do is we learn the facts of the case as best we can. These are real people. They have real struggles. They deserve to know that we know who they are, that we know the challenges they face. They deserve that. And so we have to spend a lot of time to learn their circumstances." So the next thing that we do is we think long and hard and deep about the fair result, the just outcome, the equitable disposition. And once we figured that out, we go find law to support our decision. Now, the purpose of the call was a congratulatory one. It was not to engage in a discussion of the role of the Article III judge. But I took a vow that I would do my level best to always heed the first part of that advice. Always heed the first part of that advice, that these are real people who have real struggles and we need to understand them. I took a vow that I would never followed the last part of his advice. Why? Because it's the American people who get to decide what's fair and just and equitable. And they express that through their politically accountable representatives, through members of Congress. They do that through legislation. They do that through the Constitution of the United States. I was not appointed to decide, to take my own views of what's fair and just and equitable and use them to resolve the case. That's not what our system allows. Maybe that would be a perfectly good way of running a government, but that's not the system that our government was created to do. I'm an originalist. I'm a textualist. There are many political progressives who are originalists. One is Professor Akhil Amar, who's a great originalist scholar and is a political progressive. Professor Amar, in his book, The Constitution, a Biography, which I highly recommend, says something I think quite profound. The most fundamental, I won't quote him, but I'll paraphrase him. According to Professor Amar, the most fundamental liberty protected by the Constitution is the right of we the people to set the rules by which the government, by which our society is run. And we do that through politically accountable representatives. We don't do that through judges. Our job as a judge is to be a faithful agent to we the people as they express their will through law. The Constitution has a very complicated lawmaking process. In the case of statutes, it's bicameral passage and presentment to the president. In the case of amendments to the Constitution, it's 2/3 passage in Congress, 3/4 ratification by the states. It's a very complicated process. If you note in that process, there's no description for the role of a
Judge, we need to wrap it up.
Yes. Okay. There's no role for a judge in there. So that's the lesson we learn. Thank you, Mr. Chairman.
Thank you very much, Judge.
Thank you. Anyone over here? Senator Blumenthal? Yes, sir.
Judge Griffith, I was not the one responsible for interrupting you, just...
That was me, Judge. I apologize. We're going over, and I know you didn't have a clock, so...
I mention that because Judge Griffith sat on a case very recently where I was present as the plaintiff in Trump, Blumenthal versus Trump. And thank you, Judge Griffith, for being with us and all the witnesses who are here today for giving your time to this very, very important proceeding. I want to ask particularly Ms. Clark, because there is such a strong racial justice movement in this country now. We're in the midst of a health crisis and obviously an economic emergency, but the racial justice movement is so deeply important. I asked Ms. Judge Barrett about the issue of gun violence prevention. And I brought with me the story and into the room the voice and face of Janet Rice, who lost her son, Shane Oliver, in downtown Hartford. They are Black. I also had the voice and face of Krishna and Michael Song, who lost their son Ethan, and Natalie Barden, who lost her brother. Every community, every part of the country is affected by the scourge of gun violence. Janet Rice lost her son Shane Oliver in a shooting, probably no fault of his, certainly none of hers. I wonder if you could talk about the need for sensible, common sense gun violence preventive measures. Judge Barrett has taken a position that the Second Amendment should give felons, a class of felons, without any legal support in the circuit courts, the right to possess firearms. I'm extremely concerned about the effects of that kind of approach to common sense measures like Connecticut has and other states around the country that protect everyone, background checks and emergency risk protection orders, safe storage laws, Ethan's Law, as it's known in Connecticut, because the song's son, Ethan, was killed when a gun that should have been safely stored was available to the two teenagers who were, in effect, playing with it. And perhaps tell me about the effects of striking down those kinds of laws on communities of color around the country and on the country as a whole.
Thank you for that question, Senator Blumenthal. We've examined her record very closely with respect to the Second Amendment, and Judge Barrett's Second Amendment jurisprudence reflects an originalist viewpoint. Again, we see her originalist and textualist outlook really shaping her view of the law. And her record suggests that she would be inclined to make it easier to expand individuals' rights to obtain and use guns, and that it would be more difficult for states to impose reasonable restrictions on the purchase and use of guns. And I do think that this is a very real issue for our country. We have been through a spate of mass shootings. And we also know that access to guns has devastating impacts on vulnerable communities, including communities of color. So I have deep concerns about her jurisprudence in this area.
Now, I should mention
I'm just going to pass along to the folks in the WebEx that we did lose audio in the chamber. It's not a WebEx thing. You're not alone. You're not having trouble with your internet connection. It's looks like it may be similar to what happened yesterday, but that's me now, reckless conjecture. But yeah, from that standpoint, the recording studio team's trying to work to bring the microphones in the room back up. But they can't hear in the room either. How about that? That's the easy way to word it.